The imposition of President's rule in Maharashtra today is shocking from the standpoint of law, but the Bharatiya Janata Party has played so fast and loose with well-settled constitutional principles ever since it came to power at the centre in 2014 that nothing should surprise us anymore. In this episode of Beyond the Headlines, we will analyse how the Maharashtra crisis has unfolded, what the law says about the role of the governor when an assembly election produces a hung house, and why his refusal to allow parties other than the BJP the chance to form a government is not just immoral but also completely illegal. The irony is that this is a crisis that would never have happened if the BJP had simply honoured the promise Shiv Sena leaders say they were given in the run-up to the October assembly elections, that the Sena would get to hold the chief minister's post in any coalition government that the two parties were going to form. Now, the BJP denies making this promise, but there were plenty of media reports to this effect in the weeks and months before October, which the party never contradicted. So, for my money, I'm inclined to take the Shiv Sena's claims about this on face value. But I'm getting a bit ahead of myself here. For those of you who aren't political junkies, let's remind ourselves of the assembly election result. The BJP won 105 seats, the Shiv Sena 56, the NCP 54, and the Congress 44. The assembly has 288 seats, so it's clear that no party has a majority on its own. As I said, this would not have been a problem if the BJP had simply found a way to accommodate the Shiv Sena's desire to have its person as chief minister, because their coalition would put them above the halfway mark. But it became apparent within days of the result that the BJP was unwilling to go along with this demand of its oldest political ally, and that the Sena too was not going to drop its demand either. When it became apparent that the rupture might run deeper than merely a disagreement over the share of the spoils of office, NCP leader Sharad Pawar opened a channel of communication with the Shiv Sena. The two parties together had 110 seats, and Pawar began exploring the possibility of the Congress either joining this innovative and improbable coalition or supporting it from the outside. This is when the BJP's national leadership realized they needed to resort to some games of their own. 2 weeks had already elapsed since the election results, and the BJP had not managed to get its act together. Though the party did not even stake claim, Governor Bhagat Singh Koshyari gave Chief Minister Devendra Fadnavis 48 hours to form a government. Both the governor and Fadnavis knew this was an impossible task, but the formality was essential because it was the first step in the process the BJP had to follow in order to make sure the other parties were kept out of power as well. The governor, who is a loyal RSS pracharak, for years he was active in Uttarakhand, knew exactly what was expected of him. He gave the Shiv Sena merely 24 hours to form a government, knowing full well that the time was simply not enough for the party to put all arrangements in place. After all, it needed to secure the backing of the Congress, and the two parties have been bitter political and ideological opponents in the past. When the Sena could not comply with this unreasonable 24-hour deadline, Governor Koshyari next turned to the NCP as the third largest party and gave them till the end of November the 12th to form a government. But before the deadline of 7:30 p.m. had even arrived, the governor sent in a report to the centre recommending President's rule. The pretext he had was a request from the NCP for more time, which he interpreted as a sign that the horse trading of legislators would soon commence. Having received his report, the centre moved swiftly and got President Ramnath Kovind to process the necessary paperwork double quick. As things stand now, President's rule has been imposed for 6 months. Of course, the Assembly has not been dissolved, since that requires the assent of both houses of Parliament, but the BJP game plan, I reckon, is obvious. Use this period of central rule to somehow break the other parties, as it has done in Karnataka, Arunachal Pradesh and Uttarakhand before. In other words, resort to the very act of horse trading that Governor Koshyari spoke of in seeking President's rule in Maharashtra in the first place. The Shiv Sena has already gone to the Supreme Court against this move, as will the NCP and the Congress. So let's take a look at the legal issues involved here. According to the Bombay judgment of the Supreme Court, delivered by a 9-judge constitution bench in 1994, the governor cannot unilaterally decide, based on his subjective judgment, whether government formation is impossible in a hung assembly. Before he declares that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution, this claim must first be tested on the floor of the assembly. To be fair, the Bombay judgment arose in a slightly different context. The issue then was not government formation in a hung house after an assembly election, but the dismissal by Governor P. Venkata Subbaiah in 1989 of a sitting government in Karnataka after refusing to consider the proof Chief Minister S.R. Bombay had offered of support in the assembly. The argument the governor made to justify his refusal to consider a floor test was the same that Koshyari apparently cites today: the fear of horse trading. So this is what the Supreme Court said in finding that the imposition of President's rule under those circumstances was illegal. And I would like to quote these passages in detail because they have a direct and striking bearing on the situation in Maharashtra today. It is not known from where the governor got the information that there was horse trading going on between the legislators. Even assuming that it was so, the correct and the proper course for him to adopt was to await the test on the floor of the House, which test the CM had willingly undertaken to go through on any day that the governor chose. We are of the view that this is a case where all canons of propriety were thrown to the wind, and the undue haste made by the governor in inviting the President to issue the proclamation under Article 356(1) clearly smacked of malefides. The proclamation issued by the President on the basis of the said report of the governor, and in the circumstances so obtaining, therefore equally suffered from malefides. In this connection, it is necessary to stress that the proper course for testing the strength of the ministry is holding the test on the floor of the House. That alone is the constitutionally ordained forum for seeking, openly and objectively, the claims and counterclaims in that behalf. The assessment is not a matter of private opinion of any individual, be he the governor or the President. It is capable of being demonstrated and ascertained publicly in the House. Hence, when such demonstration is possible, it is not open to bypass it and instead depend upon the subjective satisfaction of the governor or the President. Such private assessment is an anathema to the democratic principle, apart from being open to serious objections of personal malefides. In the Maharashtra case, the fundamental illegality committed by Governor Koshyari, if we go by the Bombay judgment, is his refusal to let any party other than the BJP test its ability to form a viable coalition on the floor of the House. In order to justify this illegality and decide unilaterally that a government is not possible under the circumstances, he gave the Shiv Sena and the NCP hardly any time to explore the prospect of government formation. Why? He even refused to give them as much time as he gave the BJP, and worse, didn't even bother to offer the Congress a chance either. Governor Koshyari's malefides are manifest, and I'm sure the Supreme Court, which will hopefully hear this matter on an urgent basis, will simply insist that the Bombay benchmark on a floor test be complied with. Turning briefly to the political aspects of this crisis, it is fair to say that the BJP-Shiv Sena relationship has now gone past the point of no return. Of course, a Shiv Sena-NCP alliance with Congress offering outside support seems a strange beast, and we don't know if it will even emerge or survive. But it is the logical outcome of the BJP's hegemonic politics. Until now, there's been talk of a Mahagathbandhan of parties outside the NDA coming together to confront the BJP. But after the way the BJP has treated the Shiv Sena and behaved in Maharashtra, it is likely that other BJP allies will also grow wary of what their alliance with the Saffron Party is doing to their own support base. But that's a topic for another day. For now, it's the constitutional aspect of the crisis which is paramount, because at the end of the day, The rule of law cannot be about politics and ideology, but about principles which stand above us all.